that an employer, for example, under the acquisition of genetic information section, is prohibited from intentionally requesting, requiring, or purchasing genetic information. Now, that is an intentional act, but it's not necessarily with the intent of actually accessing genetic information. An employer, for example, may make a more general medical inquiry and may take no additional steps to inform a third party that that inquiry is not to include genetic information. That is still a prohibited act under GINA. GINA would prohibit that act even if there was no specific intent to acquire genetic information. By analogy, it's analogous in some ways to what some of you may know from a more casual understanding of the way our criminal law system works. In our criminal law system, the difference between a murder charge, for example, and a negligent homicide charge has to do with the intent of the person who commits the crime. There is no intent requirement in that sense in GINA. You either are acquiring information or you are not acquiring information. Whether there was an intent to acquire actual genetic information is irrelevant. And that's important because much of the efforts that we are seeing now in terms of what the employer community is seeking is an attempt, now that GINA has been passed, to prevent any type of changes that might require them to change current practices. So the average employer would otherwise respond by saying, well, of course we never specifically ask for genetic information. Well, that's not quite the point. The point is making sure that they change their practices to ensure that they are not acquiring genetic information as the result of other inquiries. So we felt it was important to state in the preamble that distinction. The NPRM goes through, just very quickly, the employment discrimination prohibitions. It's entirely consistent with the GINA language. It acknowledges that the GINA language on discrimination mirrors other federal discrimination laws, including Title VII and the Americans with Disabilities Act, and EEOC NPRM follows this quite closely, so we didn't feel any need to specifically comment on that section. The general rule that the EEOC uses for acquisition of genetic information in the NPRM is the same as GINA. It makes it an unlawful employment practice for an employer to request, require, purchase genetic information. And in that respect, they follow quite closely to the NPRM. In terms of the exceptions, though, to the prohibition on acquisition of genetic information, the NPRM, we feel, needs to be much more closely crafted. The most importantly, probably, would be the first exception, the inadvertent request exception. That exception, in the way that the EEOC currently describes it in the NPRM, leaves it open for a number of understandings that we feel are inconsistent with GINA. The exception was meant to address what we've so often called the water cooler exception, where an employer would accidentally overhear a modest conversation between employees. What the water cooler exception or the inadvertent request exception would not address, though, are situations where employers begin to ask more probing questions, where the conversation begins to take on a tone where the employer knows or should know that genetic information could possibly be offered. And in that situation, it's quite clear that the exception should not apply. And unfortunately, that nuance is not right now expressed in the NPRM. So it's important, we felt, to bring that up to the EEOC's attention. In addition, they make in the inadvertent acquisition exception in the NPRM, they make a distinction between certain types of medical inquiries. Of course, for example, under the Americans with Disabilities Act, after a conditional offer of employment has been made, an employer can acquire medical information about their employees or potential employees in this situation, even if it's not job-related. In those situations, the EEOC's NPRM is consistent with GINA, we feel, in the sense that it requires employers to take a proactive measure to make sure that they aren't acquiring genetic information. But they make a distinction in particular with another process that occurs under the Americans with Disabilities Act, and that has to do with reasonable accommodation requests. These are requests when an employee who is disabled approaches an employer and seeks a reasonable accommodation for their disability within the workplace. In these types of situations, the NPRM is currently drafted likens that type of a relationship to the inadvertent request exception in general rule, in the sense that the employer isn't specifically necessarily asking for this type of information. So if this type of genetic information is offered to the employer during a reasonable accommodation request process, the EEOC's NPRM believes that it falls within the exception. We do not. Reasonable accommodation requests are a very extensive process of interaction between employers and employees. We feel that there is absolutely every opportunity during that process for an employer to take proactive measures to make sure that they are not inadvertently acquiring genetic information. So we believe, and we state so in our comments, that reasonable accommodation requests should not be subject to the exception and should be subject to the same requirements as any other medical inquiry would be under GINA. And we also reiterate a more general problem that we find with the NPRM, and that is that it is not particularly clear as to what proactive measures an employer actually has to take now under GINA in terms of their medical inquiries to make sure that they aren't acquiring genetic information. No specific language in the NPRM is offered, nor is the concept even particularly well addressed. So we felt in both cases to make sure to bring that to the EEOC's attention so that they could address that further. In terms of additional exceptions under the acquisition of genetic information section, has to do with an employer who offers health or genetic services to their employees. An employer who offers health or genetic services to their employees under GINA can acquire genetic information if an employee voluntarily offers that information as part of their participation in a wellness program, for example. The problem is how many wellness programs that are offered by employers are currently constructed and how that interacts with the idea of voluntary under GINA. Many employer programs currently are incentive-based wellness programs. That means that the employer offers the employee some form of remuneration for their participation in the program. That can either be a direct monetary amount, or it can be any one of a number of other forms of incentives, everything from airline miles to travel awards to merchandise. Any program, we believe, that is incentive-based cannot be called truly voluntary, particularly with the current state of the economy, few employees have the means to turn down the incentives that are offered through these wellness programs. And we feel that as a result, these wellness programs that are incentive-based are very much not voluntary, and we feel that should not fall within the exception. Additionally, even for non-incentive-based wellness programs, it's important that employees have control over the release of their personal genetic information as a result of participation. Many wellness programs, in fact, some wellness programs almost entirely are comprised of what are called health risk assessments, which are often lengthy questionnaires that ask employees a whole host of questions, including questions regarding family history. We believe that the voluntary requirement would not be met if an employer requires, as a result of participation, filling out the family history sections of a health risk questionnaire. So we felt it was important to bring to the EEOC's attention and note that either the questions on a health risk questionnaire that address genetic information should either be removed entirely or that they should be made voluntary as far as an employee's need to fill out those parts of the questionnaire in order to maintain the voluntary requirement under the program. An additional exception under this general rule on acquisition of genetic information has to do with commercially and publicly available information. That employers who, for example, might pick up a newspaper and happen to read an article that dealt with the genetic information of their employee wouldn't necessarily be responsible under GINA for that acquisition. And that was the intent of this exception. The EEOC has, in their NPRM, offered to expand that definition to include electronic media. We felt that generally that was sufficiently within the intent of the Act to do, but we felt that the framework for which the EEOC lays out this exception needed to be rethought. The exception, for example, under GINA currently does not include things like medical databases and things like court records. Even though medical databases and court records can often be public in terms of the general public's ability to access that type of information. So we felt it was important to bring to the EEOC's attention that this exception was not meant to utilize a public versus private framework in terms of what is available under the exception and what is not, but rather that the exception was meant to apply to mediums that were a heightened risk for containing genetic information, regardless of whether they were public or private. And that list could be quite extensive, and it could include everything from legal databases to members-only websites to internet-based chat rooms, professional trade materials, and the like. But that it was important to make sure that that distinction was made in this exception. An additional exception has to do with genetic monitoring in the workplace. Under GINA is a departure from the traditional law in this area. On the Americans with Disabilities Act, for example, has what is called a job-related standard for disability inquiries. That means that if an employer can prove that a medical inquiry of a current employee is somehow job-related, they can continue with that inquiry. In terms of genetic monitoring, GINA is a departure from that standard because GINA does not allow